Hello, everybody, and welcome to another episode of Virtual Legality. I'm your host, Richard Hoeg, managing member of the Hoeg Law business law firm of Northville, Michigan. And like so many episodes of Virtual Legality before, we are going to be talking about the state of California in the United States today, because the state of California has recently enacted a law that will go into effect next year that changes the way that some of the media platforms that we use so regularly and talk about so regularly here are able to sell their digital content to you, or more precisely, the licenses to digital content that they do sell through those platforms, which is really at the crux of the issue. So today we're going to talk about all of that because it made some waves in the spaces that I get my news from and that I look at when we're talking about video games and whatnot. So with that said, let's dive into Stephen Tottilo's game file. Now, you might remember Stephen Totilo from MTV or Kotaku or Axios. He now has his own kind of, I hesitate to say blog. It seems a little bit reductive. He makes articles about video games in a space that he controls himself. And I find it to be very useful. Now, I do want to give a disclaimer there because we're talking about things like false advertising and truth in advertising. And so I will give a disclaimer that says Mr. Totilo has given me a free trial to GameFile in the past. I don't currently have it because I don't want to spend money on things that I might otherwise be reporting on or engaging in here in Virtual Legality, but it is good content. He's a good writer, and he often has stuff before the other folks do. So if you're at all interested in these things, I do recommend it, but you can take however you like the fact that I was given a free trial at some point in the past to give you that recommendation. So GameFile says new law will change how digital games are sold, at least in California. Terms such as buy and purchase will be barred unless a seller clearly warns users they are paying for a license that could be revoked. Now, in case you're worried, we're not going to settle just for looking at articles in GameFile or Kotaku or some of the other things that I have here to bring up for our understanding of the law. We're going to look at the language of the law itself and also discuss how there are some ambiguities in that law. But we are going to take as a starting point what Mr. Totilo has to say about the law here in this article. Any retailer that sells a downloadable video game will soon need to warn customers, at least in the state of California, that the game they're purchasing may not be theirs to play forever. That warning will be required in California as of January 1st, thanks to AB 2426. That's Assembly Bill, I believe. A consumer protection and false advertising bill signed earlier this week by the state's governor, Gavin Newsom. The bill makes it illegal for sellers of any digital goods, games, movies, books, etc., to use terms like buy or purchase during a transaction without the inclusion of a warning about the potential impermanence of what they're paying for. Now, that's something we're going to discuss as part of what the law requires as well. This is perhaps a little bit broader than what the law actually says in terms of the summary here in this article, but it is true that the state of California has looked at the use of the buy button and the purchase button in places like the PlayStation Network or Xbox Live or the eShop if you're a Nintendo fan, or other places like Amazon Digital or Vudu now, I think Fandango at Home, any other place where you might find a digital file that you are essentially buying a license to, and said, hey, that button is maybe confusing for reasonably minded consumers, which if you've been in Virtual Legality for a while, you know is something that I have discussed with you at points in time in the past, and we'll get to that in part of this video as well. So that's the nature of this law. The main story that brought this issue to my attention was Sony's announcement at the end of last year that digital copies of purchased content from Discovery would be revoked, said the particular assembly member here, Jackie Irwin, referring to the news in December that PlayStation was about to remove access to Discovery shows that people had paid for. And if you recall, we did talk about that here in Virtual Legality with our Myth-Busted Buying Digital video. You can check that out in the playlist for Virtual Legality or otherwise on the channel. We also have covered that in other capacities in respect of whether Sony was getting sued or Apple was getting sued over their buy button, and said, our digital store is perpetuating fraud with the buy button. And I said, look, it may not be fraud insofar as it's not a lie, right? From a legal perspective, the lawyers in the room, when somebody's asking them about whether we can use a buy or purchase button, can rightfully say, yes, you can use a buy or purchase button because you are buying a license. And just like any other kind of ephemeral right, you can purchase that right, subject to certain conditions. And that's what's happening with respect to digital goods, as I think people that are regularly in Virtual Legality know. But what this California law posits, and what I think is probably correct, is that people that aren't in Virtual Legality all the time, people that aren't trained in law or otherwise reading all the terms and conditions when they play a video game, do not realize the use of the term buy or purchase is referring only to the concept of buying a license, buying access, like you buy a ticket to a concert, and not buying a copy of the video game or movie in question itself, which is a little bit distinct from buying a book or a DVD. And we're going to talk about that with respect to this particular assembly person's comments in just a minute. But I did want to mention that we have talked about this in Virtual Legality at length, and that Virtual Legality is a show supported by viewers and listeners like you. If you'd like to support the channel, we've got links in the description to Player, Patreon, which I think people are a little bit more familiar with, or of course through memberships and super chat messages that you can deliver as part of the live show. If you're watching this after the fact in replay or archive mode, please do leave a comment to the video or to the place where you are listening to this podcast, and I will try to get to any comments or questions that you have in that capacity as well. But if you'd like to support the channel, we do have those mechanisms to do it. Please don't feel obligated to do so. We like to do these videos and get this information and content out there so that we can better inform people about these questions. And in part of doing that, we have long talked about the PlayStation Network's terms and conditions because they are perhaps the most bald about this particular issue. Every one of these platforms, whether we're talking about movies or video games or music, says that you are licensed the content, you're not sold the content, and puts various restrictions around that in their terms of service. But only Sony says, hey, we're using these buttons, but those buttons don't mean what you think they mean. Use of the terms own, ownership, purchase, sale, sold, sell, rent, or buy in this agreement, or referring to the PlayStation Network agreement, or in connection with PlayStation Network content, does not mean or imply any transfer of ownership of any content, data, or software, or any intellectual property rights from Sony Interactive Entertainment, its affiliates, or its licensors to any user or third party. And I put out a tweet last week when this news was making the rounds that said, hey, you know, the fact that I've highlighted this bit of language so often, I would like to think was at least partly informative of California passing a law like this. But in truth, when we get to what the law actually does, I don't think this is actually going to move the ball very much for Sony, and we'll see why in just a minute. But I do think that this kind of concept where Sony essentially sits here and says, yes, we know we've made those buttons and those buttons are probably confusing to you, but those buttons don't think what you think they don't mean what you think they do. And we're only going to mention that in paragraph 10 of a multi-page terms of service document. And we think that makes it right for us, is probably verging on the edge of, if not false advertising, misleading advertising. And it's probably the right thing to say that a reasonable-minded consumer doesn't fully understand all of these license terms and that the content can be revoked, especially when the platform itself loses the right to transmit whatever licensed content we're talking about. And that this is probably something where you can justify more transparency from government edicts and whatnot, where you may have heard in Virtual Legality me saying that I'm a little bit reluctant to espouse compelled speech of this type, right? And we talk about these things, and it's easy to back up this transparency or this sunlight or however you want to frame a law like this. But it is important to note that this is at least a limited on what we would consider First Amendment freedom of expression, freedom of speech here, right? The state is coming in and telling an entity that is otherwise engaged in a commercial activity here that they have to say something along with what it is that they are selling. And we find that to be mostly okay in the United States. We have a number of places where that happens. You can think of drugs and the Federal Drug Administration requiring certain disclaimers on advertisements, certain things that are listed on the side of your prescription medications, or even in terms of food, in terms of what is contained within that food. And so we are generally more willing in the United States to permit the state, whether that's California, whether that's any other state, whether that's the federal government, to compel speech, to force a commercial actor to speak in certain ways if they want to engage in commerce, if they want to sell something to you. That is seen as less of an egregious affront to the First Amendment than requiring you to say something political or otherwise when you're engaged in the public discussion. And so this is one of those areas where I think even reasonably minded people could say, yes, that seems like a good idea, but I'm not sure I want Sony or Amazon or anybody else to be forced to say these things. I tend to come out on the other side. But again, I don't make virtual legalities to tell you how to feel about these things. I just want to point out that there are reasonable arguments on either side of a question like this that says, well, do we really want to force them to say these things, especially when we look at the law and see that it's not perhaps as precise as we might otherwise want to be at a kind of conceptual perfection basis. And so we'll look at that in just a minute, but I did want to point out that the PlayStation Network terms have long had this little provision in them highlighted in red on your screen that says, even though we use those buttons, they don't mean what you think. And I think that probably is a problem, and I would expect Sony to not use this language once this law goes into effect. But I don't know that they will remove it as much as change where it appears. And we'll talk about that in just a minute. Now, I did want to point out that this news made the rounds of everywhere I was looking, including video game and tech sites, as well as major news sites outside of the gaming and tech sphere, talking about, as The Verge says here, the fact that California's new law forces digital stores to admit you're just licensing content, not buying it. And this is probably a little regressive or a little reductive insofar as these companies have been saying that, right? These companies have been saying that you're only licensing the content, you're not buying it within their terms of service, within their terms and conditions. But what this law basically says is you have to highlight and separate this particular concept in a way that you aren't doing when you put it in paragraph 10 of your terms of service. And so these companies have been telling you that you are subject to the license that they've written into their terms of service. But California says that's not good enough, primarily for the same reasons that we said in our earlier videos, which is that the whole nature of where fraud exists, whether or not somebody is falsely advertising to you, is based on what a reasonable person would assume is happening in the transaction they're entering into. And with a buy button and with a purchase button, particularly one that is nested against some kind of rental button, it sure looks like you are buying something that in a different context would mean that you have perpetual rights to that movie or that music or that video game, when in fact that isn't the case, primarily because a licensor like a platform can't actually sell you something that it doesn't have the rights to itself. So Sony, except for the games that it makes itself, doesn't have a perpetual, unchangeable right to the things that it transmits through its platform to you. So it has to have a term in its license somewhere that says if the actual owner of this material somehow takes it away from us, we have to be able to cut off access, or else we're infringing all of those intellectual property rights. And that's normal, but it might not be reasonable to assume for somebody pressing the buy button that is happening behind the scenes. So it's a complicated matter, but I wanted to talk to you all about it because I do think that it can be reduced a little bit too far when we look just at headlines or the way this is reported on in the video game space. Or as IGN puts it, California's new law will force storefronts to disclose that buyers don't actually own their digitally purchased media. Very similar to the Verge headline, right? And like I just said, they're already telling you that, but they have to say it in a different way. And the disclosure is actually only one of the options that these companies have been given under the new California law. We'll talk about that as well. Kotaku uses a very similar headline. New law will force companies to admit you don't actually own digital games. And honestly, this is not the kind of thing that I think is confusing for people. They understand they're subject to licenses, but it's still important to go through this process of discussing with folks that are hitting the buy button or the purchase button what it is that they are getting. So here is the press release from Jackie Irwin, again, the assembly person that sponsored this new law. And this kind of press release in a political setting is always something that is very much in favor of the law being passed. This is designed to help get them in office or keep them in office, so we can use that tilt when we evaluate it, but there's nothing wrong with advocating for a bill that you proposed. Assembly member Jackie Irwin's consumer protection legislation, which addresses the increasingly common instance of consumers losing access to their digital media purchases through no fault of their own, was signed into law today by Governor Gavin Newsom. The legislation, AB 2426, requires sellers of digital goods such as movies, ebooks, and video games to disclose to the purchaser that they are only receiving a license to use the digital media, as opposed to implying the consumer has ownership of their digital item in the same way they would for a physical copy of a DVD or book. Now, here I think that this legislature and this legislative member is actually making the same confusing point that we saw in the headlines in The Verge and IGN and Kotaku, which is suggesting that when you purchase a digital license, you're getting something different from when you buy a physical copy of a DVD or book. But that isn't in fact the case, right? If you walk into your local bookseller or you walk into your local Best Buy and you buy a DVD or you buy a book, then you are only buying the instance of that movie or story that is contained in that book or DVD. You know this inherently, right? You don't get a license, you don't get terms and conditions or terms of service with that book or that movie because you know that you are not getting the copyright to that movie or that book. You can't just buy a copy of The Lord of the Rings and then run a printing press and sell copies of The Lord of the Rings, right? You know this inherently. But because it's not digital, it's not very easy for them to take it away from you if they otherwise don't have the intellectual property rights as a publisher themselves. And the way those contracts are written is so that they can have the rights to sell for a period of time, and anything that's sold from that period of time on is yours in the future. And the intellectual property laws of the United States and other jurisdictions around the world have coverage for this in something that we call the first sale doctrine, right? So copyright as a concept gives the creators of these things, whether it's The Lord of the Rings or whether it's Men in Black, the movie, the right to control the distribution of their movie or their book. But there are exceptions to that, the most primary of which is this first sale doctrine, which says, notwithstanding the exclusive powers that a copyright holder holds, the owner of a particular copy or phonorecord lawfully made under this title or any person authorized by such owner is entitled, without the authority of the copyright owner, to sell or otherwise dispose of the possession of that copy or phonorecord. So you can take your copy of The Lord of the Rings and sell it, but it doesn't give you the right to otherwise create a movie out of it, to create derivative works out of it, to reproduce it, to publicly otherwise display it, or do various other things with that. And we know that to be the case. We understand intrinsically, operating in the market that we do, that we don't get those rights when we buy a book or a DVD. It's a little bit more unclear when we're talking about digital goods and what you can do with a digital file for a piece of music or a movie or a video game, but it isn't actually different when we talk about this in this context. So I do think that this is confusing the issue a little bit here from the legislative member themselves, and I don't blame them. This is a confusing area of law, but I did want to point it out because getting a license to play a video game isn't so different from getting a copy of a book. It's just that you don't have that first sale concept because you don't have a specified limited one copy of that game or movie to transmit. And so the fact that this license operates differently isn't so different from buying a DVD or a book. As retailers continue to pivot away from selling physical media, the need for consumer protections on the purchase of digital media has become increasingly more important, says the assembly person. California is now the first state to recognize that when digital media retailers use terms like buy and purchase to advertise digital media licenses, they are engaged in false advertising, added Aaron Perzanowski, professor of law at the University of Michigan. Go Blue. Second disclaimer, I am a lawyer that got his law degree from the University of Michigan. I was not taught by this particular professor, probably after my time, but I am biased towards the law professors at the University of Michigan, so I should mention it here. Consumers around the world deserve to understand that when they spend money on digital movies, music, books, and games, those so-called purchases can disappear without notice. There is still important work to do in securing consumers' digital rights, but AB 2426 is a crucial step in the right direction. The task force concluded consumers would benefit from more information on the nature of the transactions they enter into, including whether they are paying for access to content or for ownership of a copy, in order to instill greater confidence and enhance participation in the online marketplace. And this law was passed in response to that task force, as well as a number of other things. And so I do agree with this overall kind of thesis. I'm a big fan of transparency and a big fan of disclosure. I want people to understand what it is that they are buying, and perhaps more importantly, what they aren't. That's one of the reasons virtual legality exists, is to have the conversations that we have had in this space about things like the PlayStation Network terms and conditions, about things like the buy button and the purchase button. And in general, I'm in favor of moves like this one. But as is the case with all such things, the proof is in the pudding. And so we have to actually go look at the law in order to understand what it is that it does. So first, we get a big section on definitions. For purposes of this section, the following definitions apply. They define clear and conspicuous. They define digital application or game. They define digital audio work, digital audio visual work, digital book, digital code, and digital good, in order to get you to the point where they actually make the law, which says it shall be unlawful for a seller of a digital good to advertise or offer for sale a digital good to a purchaser with the terms buy, purchase, or any other term which a reasonable person would understand to confer an unrestricted ownership interest in digital good, or alongside an option for a time-limited rental, unless either of the following occur. And then we'll see exactly how the companies are supposed to get out of this particular unlawful state. But it's important to note a couple of things. One, buy and purchase are specifically singled out here. So they include as an umbrella concept any other term which a reasonable person would understand to confer an unrestricted ownership interest. But specifically the words buy and purchase are identified as problematic. When one of the proposals that I had made in my prior videos was that perhaps buy a license or purchase a license could get you to a place where the consumer understands that they are not getting some copy of the good itself that will be theirs forevermore. But that would seem to not be available in this particular context because of the specific nature of including buy and purchase as kind of outlawed words. The second thing I would note is the other term which a reasonable person would understand to confer an unrestricted ownership interest in the digital good is a moving target, right? One of the things that we have mentioned in virtual legality is that fraud, reasonability, every law that really relies on the concept of reasonability changes as the public notions of what is happening change, right? If a reasonable person understands intrinsically that when they hit the buy button on Voodoo or Fandango at home or the PlayStation Network or anywhere else, that they're only getting a license, then this kind of all goes away, except for the fact that they've isolated the words buy and purchase here. So if we can get more information out there, if people can be more educated about how these things actually work, when a license applies, when it doesn't, what buy means in this context, then we wouldn't need to be as worried about people getting burned, defrauded, or otherwise lied to as part of this process. And so it does represent a moving target, and it is the kind of law that I would prefer to see basically only talk about reasonable expectations and reasonable persons, because buy and purchase might wind up having a different meaning to people in the very short term. I don't know about you, but I see that even with the generation right above me, my parents, getting different understanding of how these digital platforms work, what they can and can't do when streaming applies, how a VPN operates, various other things that we might be more familiar with or get more familiar with as the years go on, changes what people can expect in the marketplace. And so when I look at laws like this, I absolutely am in favor of transparency, but I'd rather have that transparency be directed at specifically what is confusing to a reasonable person rather than calling out words with this level of specificity. So there are issues there, but putting those aside, how do we get out of this? If we are Sony or we're Amazon or we're Voodoo or anybody else, we can get out of it if the seller receives at the time of each transaction an affirmative acknowledgement from the purchaser indicating all of the following: that the purchaser is receiving a license to the digital good, and that might work with buy a license, etc. A complete list of restrictions and conditions of the license, which is technically already included in the terms and conditions, that access to the digital good may be unilaterally revoked by the seller if they no longer hold a right to the digital good, if applicable. So you can get an affirmative acknowledgement. That would look something like a checkbox if you're taking score at home, or it could otherwise be a bit of language that you agree to before hitting the confirm on your credit card button if you're thinking about something like the Steam interface. But that would be relatively simple for one of these companies to do. And so the secondary question here is whether or not this actually does anything at all to change the behavior of these companies. Will Sony actually remove this language, or will they move it to a checkbox in the PlayStation Network store that requires an extra X button press to say, I, as purchaser, acknowledge that the use of the terms own, ownership, purchase, sale, et cetera, do not confer any of these rights. I'm only getting a license, and maybe some other tweaks to try to make sure that you're in compliance with the California law. I would propose that most companies are going to go forward and do that instead. And if that changes any behavior, great. If people didn't understand that that was what was happening. But I do have my doubts that that will actually be the net effect at the end of the day. The other option that these companies have is the disclosure you saw referenced in the Verge headline and the IGN headline and the Kotaku headline, which is that the seller can provide to the consumer before executing each transaction a clear and conspicuous statement that does both of the following: states in plain language that buying or purchasing the digital good is a license, and includes a hyperlink, QR code, or similar method to access the terms and conditions that provide full details on the license. Now, I don't know about you, but most of these platforms that I use generally have a hyperlink already to the terms and conditions. That's one of the ways that I get to them to talk to you about all of them in virtual legality. So I think that's probably already in existence. What this really changes is that there would be a conspicuous notice that the purchase button is applying only to a license. And again, I don't think that changes much of anything, but I do think that transparency is an overall net positive for this transaction. And I think it will move people towards understanding that it's a license even more in the future. Now, the one thing that you do also have to ask yourself is, will these platforms change only for California or overall? I think if they say that you're purchasing a license in California, that's probably going to stick around for the entire platform. This is probably going to apply globally for these platforms, because it doesn't make a lot of sense to remove that language in the other jurisdictions when in those other jurisdictions, it could be implied that without that reference, you're buying something different than a license. So these are the kinds of conversations that these corporations will have with their legal counsel and their compliance counsel across the world in connection with complying with this. But I would expect that this California law will change the way these kind of final purchase mechanisms look across the board on these platforms, because it's going to be a low-cost change across their entire platform. It would probably cost more to actually maintain different jurisdictional looks for these various things. And I don't anticipate that they'll lose much in the course of sales and that people will shy away from it. But they might run an A/B test for a little while to decide whether that is in fact the case. Run it in California, see if it really reduces their money, their profits. And if it does, then they might run two different types of the store. And that's interesting in and of itself. But you can see that it's a pretty limited requirement here of these companies. As I said, it's low cost. This is the kind of regulation and law that in general I can get behind. I would probably have framed this all more specifically, as the professor from the University of Michigan suggested, as a version of false advertising. I think that the federal law for the FTC Act and the California laws both have the concept that it's illegal to falsely advertise your good or service. And I would have simply said, as part of this, that this advertising that you can purchase a digital good or service that is subject to a license without referencing that license is in itself false advertising. I would have framed this in the reverse, because that can all fall under your existing precedent for false advertising and is a better fit, in my opinion, for what we're talking about here, which is that we don't want to lie to consumers about what it is that they are buying, rather than kind of putting together a whole different structure. But I'm not in charge, and there's nothing really wrong with this so much as it kind of runs parallel to the false advertising rules, when I think you could have baked them in and had a little bit more efficiency there. The section does not apply to any of the following. Any subscription-based service that advertises or offers for sale access to any digital good solely for the duration of the subscription, so Game Pass. Any digital good that is advertised or offered to a person for no monetary consideration. So that's going to be your free-to-play games. What's interesting there is that that's probably a loophole insofar as games can make a lot of money as being advertised or offered to a person for no monetary consideration, with microtransactions and other things that are sold within the game or even the platform, if we're thinking of something like Roblox, right? So that's one area where you might see companies start to move into trying to use that loophole if this California law proves to be problematic for their revenues or profits. Finally, it does not apply to any digital good that is advertised or offered to a person that the seller cannot revoke access to after the transaction, which includes making the digital good available at the time of purchase for permanent offline download to an external storage source to be used without a connection to the internet. Now, this is a little bit ambiguous, and we will see, in fact, that Mr. Totillo, the author of the original article, found it to be a little bit ambiguous. He says, I keep seeing some confusion cropping up over the California law. As noted in my story, it does not cover games that can be downloaded and played offline. It's targeted at media that requires an internet connection that the seller could revoke access to. But he rescinded this, saying the confusion was in fact mine. The law is indeed intended to impact nearly all digitally quote-unquote sold games. After double-checking with the office of the legislator behind the law, it's clear to me that Exemption C, the one we just read, is not intended for games that merely can be played offline. It's intended for digital games that have no DRM. Hence her citation of GOG's approach in our original interview. Sorry about that. I've updated my post. Indeed, he did. But I wanted to point out that, like any other statute, the legislature is not, in fact, the final arbiters of what this thing says. They are essentially the programmers putting the code into the engine that will ultimately be interpreted by courts around California and perhaps further jurisdictions, depending on exactly how this is applied. And so when you have a bit of language like this that could be read to say, hey, if I can download the game to my PlayStation and it runs fine without access to the network, is PlayStation even impacted by this? If I can download something from Voodoo and keep it on my smart TV or wherever else it might be held, are they impacted by this? And the answer is yes. The intent is to impact those things because of the definitions used as part of this law, but it isn't obvious on its face. And a smart guy like Mr. Totillo got lost in it, and you can imagine a judge getting lost in it as well. So it's always difficult when evaluating statutes before they're executed and kind of run through how the courts are going to read these things to decide whether they're good or bad or otherwise. But I do think there are some ambiguities here that could potentially cause trouble for California, and it'll be interesting to see if they do, in fact, do so. But I have to say, I did read this as suggesting that if you've got any kind of check-in at all, it's going to be a problem. And a PlayStation game, a Nintendo Switch game, an Xbox game, still for the most part has a check-in, even if you're going to play it offline. You might see a box very quickly on the PlayStation or the Nintendo that says, checking to see if access is allowed, checking your licenses. The PlayStation Network went down, I think, for a number of people over the last day, and they weren't able to access the games that they owned licenses to because of that check-in kind of concept. And that would certainly apply to all of this here if Sony retains the right to revoke and has that kind of online check-in. But it can be unclear as it's used in particularity, and especially when a company is motivated to fight its application to them in the future. So we'll have to keep our eyes on that. But I did want to point out that reasonable people can get confused by the statutory language. That's not unusual. That's not really even a comment on the nature of this law, which I think is relatively well written, but has some areas for potential loopholes that I can at least see from afar. And it'll be interesting to see how it plays out in real time. Now, last but not least, let's see what else I've got here. I did want to flag this particular article, which was about California cracking down on misleading online purchases in a outlet called ReadWrite that talks about, again, the false advertising component of this, talks about why it was passed, talks about the fact that Ubisoft withdrew access to The Crew game, which raised the ire of this particular assembly person. And we would have seen that in the press release had we read that part. But I did want to flag that before we got to the end here, where I will pick up any memberships and super chats. Thank you all for being here with me today, as well as answer any other questions or comments that you all might have on this particular topic. Overall, I want people to understand what's been done here in California. I want people to know that I'm in general in favor of transparency, but there are reasonable arguments against a law like this with respect to forcing or compelling speech from commercial actors, and there are reasonable arguments against the way the law in specificity is written. And so I don't want anybody out there just claiming that it's all good or all bad in any particular way. But I do want to encourage the conversation both here and elsewhere online, because this is good stuff. This is moving forward with the digital marketplace and these states essentially catching up to regulations, rules, and interpretations that probably should have been done a little bit in the past. But as I've said here in Virtual Legality, the law is a slow beast, and it tends to adapt very slowly to technological advancement. So with that all said, does anybody have any comments? Are there any membership things that I need to catch up on? I do want to shout out Just Because, who gifted 10 Hoeg Law memberships before the show, and Brentwood Chic, who gifted 10 Hoeg Law memberships during the show. Thank you so much to both of you. I cannot do this without support from folks like you, from the listeners, from the commenters, from the likes, the upvotes, the downvotes. YouTube likes it all. Please do engage however you see fit with this content, and I will keep making it for you as long as I am able to do so. So thank you, Just Because. Thank you, Brentwood Chic. I really appreciate it. And with that said, let's see if there are any other questions. And please do flag them with an @HoegLaw or a question : or anything else that'll let me see it. Tigerette asks, do you think this law will catch on in other states that tend to be pro-public rights and strong attorney general? Honestly, I don't see this law as one with a lot of downsides. You see Sony headquartered in California. You see various of the other big tech platforms headquartered in California. So you would expect California to be the most cautious about offending one of these companies. But of course, California is kind of on the bleeding edge of the interpretation of a lot of these rules. We saw that with the application of the unfair competition rule to the Apple and Epic case. We see it all the time with respect to things like this, which are very kind of consumer rights facing. So I do think you might see it adopted in other states. I think it's a good idea. I think there's very low risk of a lot of negativity towards this particular kind of rule. But the question I would have is exactly how these look in various other jurisdictions, because this is not at all the kind of most efficient, cleanest, smallest change to the law way to write one of these. And so I'd be more likely to see something that really does just say, hey, for purposes of our false advertising statute, which basically every jurisdiction has, it will be deemed false advertising for you to use, buy, or purchase, or something that a reasonable person would think gives them universal perpetual rights to something if it is in fact a non-perpetual restricted license subject to terms and conditions. That just saying that in specificity that this will be false advertising if you do something this way is probably enough in some of these other jurisdictions. So I might expect something more along those lines. But thank you for the question. I really appreciate it. And I hope I'm being helpful in helping folks understand what's going on. Bad as a Hog asks the question, is the fact that Sony is a California company relevant here? It is in so fact as they cannot easily escape California lawmaking, yes. For the most part, you have to comply with whatever laws you're selling product or services into. So that's going to affect most of these national and global companies in whatever jurisdiction might pass something like this. But if you're headquartered there, it's really difficult for you to move your assets around or not get pinged by this. So yes, it matters that they are in California, that this is a California law. But even if they were not in California, the fact that they would sell copies of things into California, all of these platforms are going to have to take into account the passage of this law. Certainly their compliance folks, their legal teams understand that this just passed and are having this conversation in email chains already. I can pretty much guarantee that. Andre says it's a slow beast. Nonetheless, it will devour any who try to evade it. About the law, yes, I think for the most part, the law does catch up to you, although there are certainly exceptions to that in our history and other jurisdictions' histories. But yes, particularly with respect to technology, the law moves especially slowly. And you can see this sometimes if you read through Supreme Court comments or Supreme Court opinions on tech-related things. I think I did a video in Virtual Legality about the Supreme Court just totally missing the point on a tech case not so long ago, a couple of years ago. But you can look up that on the channel. I don't actually remember what case I'm talking about in this context, so I apologize for that. But I know I definitely had a video that talks about that. And unfortunately, that's just the nature of the beast. In order to have that level of expertise in the law, you have to be of a certain age. And at a certain age, you probably aren't on the bleeding edge of technology. I know I'm certainly not at this point in my career in life. And so I do my best here in Virtual Legality, but I tell even my clients that are doing really advanced stuff with software or technology or life sciences or what have you, that at the end of the day, I will follow along. I'm really interested in your business. I think this is exciting stuff, but I am just the lawyer. And I know my contracts. I know my terms. I know the various things we talk about here in Virtual Legality. But when you're talking about that James Bond science thing that is going to change or revolutionize everything with just a gel, I am as much a layperson in the audience being wowed by your presentation as anybody else. So yeah, Cajun Bowser, I can read. I can. Specifically SIE, yeah, they can't get around this. No, anybody that's headquartered in California can't really escape the application of the law. Newsbit, I'm late, just starting, but isn't every game purchase just a license? Same with the DVD. It's limited in how you use it. Like you can't sell tickets to a movie and play DVD. Yes, you'll get to that section of the video when I talk about that, where I say pretty much exactly the same thing. But there is this kind of notion that digital is different because you don't have that first sale copy to move on. Even when we understand that when you buy a book or a DVD, you aren't getting all of the copyrights to the underlying movie. You're only getting the rights to essentially play that movie or read that book in your own home for non-commercial purposes. Right. And we understand that, but digital is still kind of a new frontier for the law and the application of the law. And so I think this is a good move. This is a move that probably is a long time coming to make sure that consumers understand what they're getting the rights to. And that's probably not, I think it should be said, the audience here in Virtual Legality. It's probably not the audience even that is regularly reading The Verge or Kotaku or IGN or the various places that I showed you the articles from on this topic. But overall, people that go on and hit the Amazon movie link and say buy, and then find out 2 months later that that has to be removed because Amazon lost the underlying rights to the source material, and they're surprised by that. I do think it's okay for us to want transparency there and to have those consumers have a more understandable transaction, because people can be taken advantage of. We can't expect everybody to understand every aspect of licensing or intellectual property at all times in their lives. I wouldn't apply that even to an intellectual property lawyer. So yeah, I think that's an important part of this conversation. A. Hettinger says, new spin, the difference is you have first sale on a DVD. Yes, exactly. You don't get that for most games. I mean, you do to the extent that you go and buy a physical copy of the game, of course, but first sale only applies to physical copies and is a difference in the way that digital and physical sales are made, because there is no limiting reactant to how many times you could copy a digital thing without a loss in fidelity. So that's an area where the copyright laws, the intellectual property laws overall could probably use some shoring up. A legislature or assembly person or House of Representatives member going in and saying, we need to talk about not necessarily that digital copies should have a first sale doctrine, although that's certainly an option to equate the two, but what exactly the rights are and what they aren't, and the notices that are required for the copies of digital things that you are getting, and the fact that you don't have that first sale doctrine. Again, I think disclosure, clarity, sunshine is the best answer to most of these advertising and commercial transaction issues. Kim Ellen says this is the updated Steam terms of service, I believe. Clarity is a good thing. It wouldn't surprise me if Steam had already updated. In fact, I think I got a window that said Steam had updated their terms. I just hadn't read it yet. But that could be what they are adjusting for in this kind of context. Steam, I don't think operates in California. I believe they're in Washington, but they certainly sell a lot of things into California, so they wouldn't be looking at this as well. Parallax Abstraction says, hey, Rick, still grinding away at work, but glad to see you on again. I'm trying to do this more often. Just did the Pal World episode last week, which I was pretty proud of. Seemed to go well and seemed to get good context and comments about that particular issue with Nintendo. And now we're talking about another thing that I wanted to talk about, and probably have a few more topics that I'll hit in the near future. But I really do appreciate everybody that's been with Virtual Legality, the channel, me, this whole time, because it's been a long road back to even being able to do these kinds of ad hoc conversations in Virtual Legality. And I do apologize for not having more content out there for the remainder of this year or previous to this, the year prior. But I really appreciate everyone that's here. I gave 10 minutes notice, and we have 150 plus people having this conversation about a California law that may or may not apply to any given person in the chat. I really appreciate it. I think it's awesome. I want to have these conversations more and more often. So thank you to everyone here. And let's see if I have any more questions that I want to hit. Please, again, if you do have a question or comment, just mark it with an @HoegLaw or a Q or a comment, or of course a super chat, but don't feel obligated to do any of that if you're not so inclined. And then we will catch you on the next Virtual Legality. So Michael JM says, I feel this is a step in the right direction. I do too, broadly. In the execution, leaves something to be desired, and we'll see exactly how it plays out in the future. I question whether it actually moves the needle on consumer confusion. I think every kind of news item that happens on this score moves the needle a little bit. Is this going to be the final blow that finally helps every consumer understand what it is that they're getting from the PlayStation Network or from anywhere else that they purchased their digital goods from? Probably not. But every time a news item like this happens, every time a legislature moves forward with a transparency item like this, I'd like to think that the reasonable consumer becomes a little bit more knowledgeable about what's happening. And that overall is good for the entire market. Stephanie Hu says it might become the law everywhere eventually. I think so. I think this level of transparency is relatively non-objectionable to most folks that are looking at it. I do think because of that moving target of reasonability, it might not be necessary in the long term. And the medium-term version of this law might be just applying to digital goods, requiring you to be reasonably transparent on what a license is giving you and not, and that ultimately becomes something that consumers automatically are understanding of. Right, that you do automatically understand without reading any of the internal pages of a book or the internal copy on a DVD, that you can't project it out into your own movie theater and collect ticket money for it, that we understand these various things about what it is that we're buying when we buy a copy of something could ultimately, in the long term, be applied to digital goods. But we're still in that transition period between when digital goods didn't exist, they weren't a thing at all, and when they are just ubiquitous everywhere in the marketplace. MZ, thank you for being a member for almost 2 years. Kiddo's a bit crestfallen on being reminded the games we've bought on Steam are just licenses to play them, not ours forever. Same with audiobooks. Well, forever is a long time, right? So, I mean, I do think that you can feel a certain amount of comfort that these companies that have been operating in this capacity for a while are likely to continue operating in this capacity for a while. I think I have said in Virtual Legality or in other contexts on this channel that one of the reasons that I invested in the Vudu ecosystem for my TV and movie watching needs was that Walmart backing them, Walmart created Vudu, was essentially enough of a proof of life for me to believe that it was going to exist in a reasonable capacity for at least the likely long length of time that I would want to watch these various things. And so I do suggest to everybody that's entering into any digital ecosystem that you try to only invest in things that you think are going to have existence and security and be run properly for the length of time that you would want access to the things, because all of these companies, if they go under, are not going to be able to maintain their platforms in the long run anyway. So I do think that it's fair to say, hey, yes, Valve could go under, Steam could go under. That would be a bad day. That would be a bad day for a lot of people, but there are mechanisms in place. There are things that you can look at to try to protect you from the worst case scenario. And one of the things with things like movies, I use Movies Anywhere, I believe it's called, that allows you to essentially put licenses in different lockers at various platforms to help kind of diversify your portfolio so that you aren't just invested in one of these storefronts or one of these platforms. And I think the more that consumers are aware that this is what they are getting, the more there will be kind of a natural pressure in the marketplace to have those safety valves. And I think everybody benefits from those safety valves in the long run. So don't be crestfallen. Just be understanding of the situation and let that help value your purchases in the future. But thank you so much for the comment, MZ. I really appreciate it. God is a Hog. What is your opinion on the Stop Killing Games initiative in the EU? Do you think it's realistic? My understanding is that's the name of the petition from Accursed Farms. Is that correct, Bad as a Hog? About essentially supporting games that have an online component or creating some kind of alternative to access those games. Accursed Farms has long been a proponent of archival of video games. I think you might recall early on in Virtual Legality, I had kind of a not debate, but a set of reaction videos that went with Accursed Farms, and then a conversation with him about whether or not games as a service are fraud. And while I disagree with those definitions, I certainly am in favor of people wanting to have more archival ability with respect to video games and digital goods in general. What I'm not in favor of is forcing costly mechanisms of retention on the companies themselves, because I think we wind up getting less products and services in the long term. And I think it's very difficult for a regulatory body of any kind to determine what the appropriate amount of costs for that are. So what I'd prefer to see, and maybe the petition is doing this more than I'm giving it credit for, is essentially a groundswell of market requesting of that support so that it's a cost to companies that don't do it, that they're going to lose out on profits and revenues if they don't give you that kind of certification or security blanket. And to the extent that they don't do that, they're going to lose the sales that they would otherwise have. And so they decide to do it because the revenue equation winds up being what they want it to do. I think asking the European Union to kind of enforce a blanket level of costs on these companies is probably not the way to go. But reasonable minds can differ on these things. And I am not sitting here looking at the petition terms themselves, so I can't really speak to it with specificity. So hopefully that's helpful. If it wasn't helpful, I apologize in advance. Papa Rick says, I'm super late. Hi, everyone. Hi, Papa Rick. I was in a meeting at work, and I was following a Nintendo shutting down another Switch emulator. Wild day. Yep, Nintendo doesn't like the emulators. That's certainly the case. So, Papa Rick, thank you for the update. And thank you for popping in to our impromptu live show with about 10 minutes notice for everybody. Thank you so much. Tigerette, forever, like the Blockbuster Lifetime Rental Pass. Well, that's a great example, actually, Tigerette, right? And I have certainly invested in MMOs that have a monthly payment requirement, and I've invested in their lifetime pass because I wanted to get at least 18 months of value out of it, and that's where the cost equation kind of came out. But I never bought that under the assumption that it would last for 40 years. I just really wanted to beat what I thought would be the monthly payment, and I really hate having kind of debt drags on my monthly revenue sources, and that's just a me thing. But yes, it's certainly the case that when you talk about a lifetime pass or lifetime entry, whatever it might be, you are buying it on the understanding that it's a kind of investment in the company itself and its continuing existence. And so to some extent, that's what you're buying with a license to digital goods, certainly. Brentwood Chic, almost 2 years. Thank you, Brentwood Chic. I really appreciate you being a member for so long. It's really nice of you, and I really appreciate the support. Gracefully Insane has as a comment, I feel like the killing of games is part of a larger issue with media getting killed off that basically makes it inaccessible without piracy. I think that's a bigger conversation, but certainly the fact that games media is being reduced in size and scope, along with all other kinds of media, if we're being honest, right? This is not a games unique kind of concept, does impact the way we understand the various aspects of news and life around us. And I think they are connected, even if I don't think that they're as direct as you might suggest in your comment here. So thank you for the comment. And I do appreciate that memberships. See, I floated, my brain floated away there for a second, everybody. That I do appreciate that businesses and media and the reduction in scope of those things can change the way we understand the world around us. Kai Mellon says, my lifetime membership to LiveJournal, that is all the time being redefined when I bother to look. Yeah, any type of lifetime membership. You could have a gym lifetime membership, and then they close the gym right next to you, and the closest one you can get to is 3 hours away, right? Every one of these things that's kind of a long-term perpetual understanding is an investment in one of these companies. And I think we understand that a little bit more inherently in the more traditional marketplaces. But the better people can understand that in the digital marketplaces, the better off we're all going to be. Because to the extent people are uncomfortable with that, the companies are going to have to find more security blankets in different ways to get us those goods if they're going to continue in existence on their own. So that's my feeling on that. Tiggerette. Thanks, Hogla. And it's TIGGR like Tigger, but a lady Tigger, Tiggerette. Thanks again for the great stream. Smiling emoji. Yes, I meant to say Tiggerette. I apologize for Tigerette. It's because the Tigers are in the playoffs right now, folks. The Detroit Tigers that were however many games out of the playoffs in Major League Baseball a month ago are having their playoff game right now. And even though it's right now, I chose to spend it with you because I wanted to have this conversation, and I'll check on the Tigers afterwards. So everybody that's a Tigers fan that watched me instead, I'm sorry about that. But hopefully they're winning when we get back to the game. And yes, it is Tiggerette, not Tigerette. I apologize for that. All right, everybody. Thank you so much for being here today. Thank you so much for having this conversation. If you thought this was helpful, give it a like. If you thought this was tremendously unhelpful, give it an unlike, because YouTube likes whatever buttons you hit on it. Otherwise, share it around with folks that might be interested in this. And please do let folks know that we're having these conversations once again in Virtual Legality. I very much appreciate each and every one of you. Thank you so much for being here, and I'll catch you on the next episode, whenever that might be.
Virtual Legality is a YouTube video series with audio podcast versions presented as commentary and for education and entertainment purposes only. It does not constitute legal advice and does not create an attorney-client relationship. If you have legal questions about the topics discussed, please consult your own legal counsel.